Hello friends, in this brief video, we will discuss the Intermediary Guidelines Digital Media Ethics Code rules, which is actually published under the Information Technology Act 2000. This rule was originally published or notified in 2021. Subsequently, it underwent an amendment in 2023, where certain aspects of gaming companies was added. They were called gaming intermediaries. And now the synthetically generated AI content has been brought under certain, say, regulations again through this particular code. Instead of passing a separate AI regulation in India, we have started using Information Technology Act itself rightly as a regulation to be extended to the AI scenario. This synthetically generated AI content related regulations will be effective from 20th of February 2026. That is it will become effective in a day or two. Now, the relevance of this particular act for the purpose of DPDPA observers has to be looked at from multiple viewpoints. One is a data fiduciary is an organization which is processing personal data and determines the purpose and means of the processing. Now, intermediary under the Information Technology Act is essentially an organization which is a conduit to third-party information. In case an organization is using an information for its own use, it will not be an intermediary, it will become a data fiduciary. Now, data fiduciaries today handle AI generated content, and we have already come up with DGPSI AI as a framework for AI deployers. So this particular regulation becomes relevant because it talks about synthetically generated information. Now, under DGPSI, we have already said compliance to ITA 2000 is part of the DGPSI full version because Section 72 capital A is of ITA 2000 is applicable, and compensation by data principles will continue to be given under ITA 2000 and not under DPDPA. So because of these various requirements, anything which is done for ITA 2000 will also have an effect on the DPDPA. And therefore, we need to look at how this particular regulation impacts all of the companies who are either processing personal data or using AI for processing personal data. Now, this 2021 notification was a comprehensive notification on intermediary guidelines, which was actually done both by the Information Technology Minister at that time and the Information and Broadcasting Minister in a joint press conference. So they brought the Digital Media Ethics Code also into this intermediary. So it was a very important regulation. Now, subsequently, changes have happened because of the gaming company, and now this 2026 changes, and the new guidelines, therefore, is something which is a very huge, say, code for all IT users, some of whom may also be data fiduciaries or data processors or joint data fiduciaries under the DPDPA. One of the important things which this particular amendment recognizes is that it recognizes and defines something called synthetically generated information, SGI, Basically, today, if you look at any YouTube or any social media, including X, lot of the data is generated using AI. There are AI bots who actually manage the data all by themselves, and there are also individuals who actually use AI and create either text or audio visuals and then post it on the social media. So this regulation tries to recognize any information as synthetically generated information in case it comes with an audio visual or audio visual information. So basically, this applies to such content, audio, visual, and audiovisual content, which is artificially or algorithmically created, generated, modified, and used using a computer resource. The use of the word algorithmically created in this rule is important because there has been a debate whether every software is being an algorithm. Does this algorithmic word is to be associated with the AI? Definitely, I think in this particular rule, they have used the word algorithmic creation as basically the creation with an automated uh, generation of content. This is also important because DPDPA, in terms of significant data fiduciaries, talks of a audit, specific audit, if any algorithm is being used, and whether that algorithm word is applicable to all software or only to AI will continue to be debated. But we have always felt that it is better to consider algorithm as something related to AI, and every other software anyway may use a lesser version of an software. Okay. So one question which came up when this particular rule was released as a draft earlier was that what about the lot of text material which is generated through artificial intelligence? Now, a clarification has been issued both on the fact that a text in association with an audiovisual obviously comes under the synthetically generated information, and at the same time, text itself is considered as an information, and therefore, any violation of law using only text is also something which becomes a contravention of a law, invoking, let us say, the Bharatiya Nyaya Samhita or ITA 2000 offences. So, a clarification has also been added that routine good faith editing, formatting, enhancement or technical correction, color adjustment, and so on need not be considered as SGI and subjected to the restrictions which are given in this particular regulation. So I think this was one of the objections which were there before this when the public viewpoint was asked. So it may not be directly applicable to pure text, but pure text being information, anyway, it cannot escape the regulation. So that is also clarified as part of this amendment. But if text is associated with a video, obviously it comes under the SGI category. Now, what does this amendment talk about? One thing it talks about is that a publisher of this content has to follow some due diligence. Now, what is this due diligence? One of the things he is required to do is once every 3 months, he should actually inform the users about the important obligations and consequences relating to the use of its platform. When I am a platform, I am giving certain tools for synthetically generated AI content or generation of such content. I have to provide a warning to the users every 3 months, which means that this becomes a routine. Okay. Now, this periodic user information includes that you may be, your account may be terminated, your account may be suspended, we will have to remove your information and so on in case there is anything which is not considered lawful. At the same time, there could be user liability on unlawful acts, and where applicable, the intermediary's obligation to report information and violations involving offences are mandatorily reportable under law. So the intermediary or the publisher cannot say this something some user posted this content, I am not aware of it. He has to actually technically make it feasible for him to identify such content and then take action. Under one of these sub-rules, it prescribes that the publisher or the intermediary has to deploy technical measures, first of all, to prevent unlawful SGI and explicitly prohibit certain high-risk SGI and mandatorily label and provenance embedding for SGI, which is allowed to be published, and safeguards to prevent tampering or removal of such labels also is required to be taken note of. This will be applicable when the intermediary is enabling or facilitating creation, generation, modification, etc. of SGI. And it includes the AI image or video generation, voice synthesis or cloning services, platforms or tools enabling manipulation of audio, visual, etc., platforms that facilitate publication or dissemination of SGI. Now, as far as the prevention of unlawful SGI content is concerned, this applies to what is called high-risk unlawful SGI. Basically, it covers issues such as content which may be considered as exploiting sexually the children, then non-consensual intimate imagery or obscene image, including content invasive of bodily privacy. Okay, so there are a lot of say restrictions as far as high-risk unlawful SGI is concerned. In the SGI resulting in creation, generation, modification, and alteration of any false document or false electronic record, including deep fakes, are considered high risk. Then SGI relating to preparation, development, procurement, or of explosive material, arms, ammunition is also high risk. Then SGI that falsely depicts or portrays a natural person or a real world event by misrepresenting misrepresentation likely to deceive, including misrepresentation of identity, voice, conduct, etc., will also be considered as a high-risk unlawful SGI. Now, the labeling requirement which the rules suggest is that a clear and prominent display of a notice is required to be made for SGI. In both the visual and audio content. Earlier, it used to talk of 10% space or something like that. Now that has been removed. It just says it should be prominently displayed and embedded with permanent metadata or technical provenance mechanisms to the extent technically feasible, including a unique identifier to enable identification of such information as SGI and so on. And this is the labeling requirement, which has to be taken care of by the person who is producing the content, or a website or a service provider who is providing the services for generation of such synthetically generated content. This is something which also assists the AI generating platform to ensure that their copyright is properly protected by getting embedded into the output. Now, when the user creates, uploads synthetically generated information, then at that time he should not remove this labeling. So one, technically it should be done like that, and then it is also will be considered as an offense as far as the user is concerned. Obviously, our current Information Technology Act itself is sufficient for this purpose, because Section 66 talks about any changes in an electronic document being without authorization being considered as an offense. Okay. Now, in case the publisher has observed any such any violation of the SGI content, then the publisher or the intermediary may take actions such as removal of the content, disabling of access, suspension and termination of the user account, and where required, even inform competent authority about any violation of law. So that is the responsibility of the intermediary. Now, as far as the removal of data is concerned, one requirement is that when an intermediary gets the actual knowledge that some content has been synthetically generated, and it has been pointed out by an appropriate authority of the government or a court that it has to be removed, then the intermediary must remove or disable the access within 3 hours. Earlier, there was a time for 36 hours, which is applicable to intermediaries. Now, within 3 hours after receiving any court order or an order from an appropriate government authority, then the content has to be removed. Now, in case somebody gives a notice with a complaint or something like that about what we can say is a high-risk information, including nudity, sexual content, morphed content, which is deepfake, impersonation, etc. Such content has to be removed within 2 hours of receipt of complaint. So the removal responsibilities have been given a very, very strict timeline. In addition, the grievance redressal related to the synthetically generated content, some changes have been made. One is that the resolution of the grievance has to be done within 7 days from the receipt of the grievance. Of course, the acknowledgement has to be done within 24 hours, but resolution should be done within 7 days, which is a reduction from the earlier 15 days. Then the removal or disabling of access, if it gets into a dispute, that also should be resolved within 3 days instead of the earlier within 36 hours instead of the earlier 72 hours. Now, the rules clarify that if an intermediary removes or disables access, then that will not be considered as a violation of ITA 2000 requirement that an intermediary should not interfere with the content. So this is basically the new synthetically generated AI content regulation embedded into the intermediary guidelines. This is of importance both for ITA 2000 followers as well as the DPDPA followers. Of course, when an intermediary does not follow these intermediary guidelines, what happens is that they will lose Section 79 responsibilities, safeguards of against liabilities, and the user, of course, will be liable for whatever offenses are there in the respective laws. So, thank you, friends. This is what I wanted to share about the latest change in ITA 2000 intermediary liabilities. Thank you.